Will do. Thank you. I'm about to go conduct an interview with the Attorney General of the state of Arizona. The state Attorney General is the legal advisor to the governor as well as to the heads of all state agencies. That includes, of course, the Arizona Department of Real Estate. So, I will not be interviewing to get opinions. I will be interviewing to get the facts, because when it comes to Arizona fair housing law, the Arizona Attorney General has the final word. By the way, please do not call the AG's office and ask for an interview after seeing this video. Just to reiterate, this is fictional. It is a dramatization only.
Why don't you have a seat, and we'll get started.
Thank you. Just a quick microphone test before I begin. Okay, my first question is, what exactly happens in this office when someone files a fair housing complaint?
Several things. First, we give notice to the aggrieved person that the complaint has been received.
Ah, that way the complainant is not just left hanging.
Exactly. And that's a very important part of the process. Then, after we have read and researched the complaint, we advise the aggrieved person of the time limits and choice of forums that are available under the Arizona Fair Housing Act. And do pay careful attention to the words, choice of forums available.
Ah yes, because there are a lot of people who think that a court of law is the only forum available.
That's right, and as you know, that's not the case. In fact, most fair housing disputes settle out of court.
Yes, true enough, true enough. And so, after you've given the complainant the proper notices, then what happens?
Well, then it's time to notify the person who allegedly committed the violation.
And, is there a deadline for you to notify the respondent?
When we notify the respondent, we must do so within 20 days of the complaint.
So, with that kind of statutory deadline for notice to the respondent, your staff must really move on these complaints pretty efficiently, right?
That's correct. This office takes fair housing complaints very seriously.
Well, is there any special way that you have to notify the respondents? Or do you just call them up?
No, Jack. We don't just call them up. The form of the notice is mandated by statute. The notice must contain specific words identifying the alleged discriminatory housing practice, and advising the respondent of his or her procedural rights and obligations. The notice must also include a copy of the original complaint.
Now, why do you have to send a copy of the original complaint? Wouldn't it be easier just to send a summary?
Yes, a summary would certainly be easier, but, Jack, this is America. Respondents have rights too. Specifically, the right to face their accusers. The respondent needs to see the original complaint to know exactly who his or her accuser is, and what exactly the accuser is alleging.
And is the form of the response mandated by statute too?
Of course. The respondent must file an answer to the complaint within 10 days after receipt of the notice and copy. The answer must be in writing, under oath, and in the form prescribed by the Attorney General. That would be me. Also, an answer may be amended at any time, and does not inhibit the investigation of a complaint.
Wow! I always tell my students and my salespersons, fair housing is serious business. I guess I'm getting a dose of reality, too.